So, here is the fundamental concept that is absolutely essential for you to fully comprehend regarding the intricate mechanics of how criminal defense strategies are actually formulated and executed within the high-pressure environment of high-stakes litigation. I ask that you remain attentive and stay with me through this explanation, because this provides critically important context that is necessary for understanding the gravity of the information I am about to disclose to you. When you are in the process of meticulously constructing a legal defense for an individual who is facing serious and potentially life-altering criminal charges, you must first identify your single strongest asset, your most unimpeachable witness, and your most compelling piece of evidence, which serves as the absolute cornerstone upon which every other aspect of your case rests. You proceed to build your entire legal architecture and strategy around that specific foundational element, ensuring that every part of the structure relies on its stability. Your legal motions reference it repeatedly, your public statements rely heavily on its credibility, and your negotiations with prosecutors assume its unshakable truth as a given fact. Every single tactical decision and argument flows directly from that central, supportive pillar of your case. However, when that essential support pillar does not merely develop a fracture under pressure but instead completely inverts its intended function, transforming into a formidable weapon that is aimed squarely at your own client, you do not simply lose a solitary piece of evidence. Rather, you forfeit the entire structural integrity and foundational logic of your defense presentation. The metaphorical building does not simply weaken or sag under the stress. It collapses entirely into rubble. That catastrophic structural failure is precisely the scenario that has just unfolded regarding Donald Trump. What we are learning this evening from multiple independent sources who possess direct, first-hand knowledge of the evolving situation is that Trump's legal defense team has experienced what legal scholars would unhesitatingly classify as a catastrophic strategic failure of the highest order. Their undisputed star witness, the very individual around whom their entire legal strategy was carefully and deliberately constructed, has flipped allegiance to the prosecution, and they have done so not in some minor hedging or limited capacity of cooperation. We are speaking here about full and unreserved cooperation, complete and unrestricted testimony, and the total documentary production of every relevant file. Now, permit me to take a moment to explain exactly why this particular development is fundamentally different in nature from the dozens of other legal setbacks we have observed Trump navigate over the past several years. Because I acknowledge that there is a natural tendency, after everything we have witnessed in this era, to treat each new shocking revelation as if it were merely another typical Tuesday in the chaotic world of American politics. But I assure you, this situation is definitively not that. This specific witness, and we are being deliberately careful with our language here because their identity is currently under strict protection, was physically present for every single critical meeting that took place. They possessed unrestricted access to every sensitive document involved in the case. They were, quite literally, in the room where it happened, to borrow a well-known phrase from popular culture. And according to confidential sources positioned deeply inside the Manhattan District Attorney's office, this individual has just agreed to testify under oath about absolutely everything they witnessed during that entire period. They are testifying about everything. Here is the precise sequence of events, as we currently understand them to have unfolded as of tonight. On January 7th, just a few short days ago, Trump's legal team was still expressing robust confidence to reporters, projecting an air of invincibility. They claimed the defense was solid, they asserted their witness was completely reliable, and they maintained that their strategy was logically sound. They insisted that the prosecution had significantly overreached in its charges and would ultimately fail when tested in court. Then came the morning of January 8th. Prosecutors executed a surprise search warrant at the witness's private residence, an action that caught everyone off guard. And what the investigators discovered there apparently shocked even the most seasoned professionals who have spent their entire careers pursuing complex white-collar crime. We are talking about detailed financial records documenting millions of dollars in previously undisclosed payments. They found encrypted communications that, once decrypted by specialists, revealed the mechanics of the alleged conspiracy in granular, undeniable detail. And here is the part of the discovery that matters most of all: audio recordings. Multiple audio recordings of conversations with Trump himself, discussing the alleged illegal activities in what sources describe as explicit, unambiguous terms. The witness was brought in for intense questioning that very same day. By January 9th, less than 24 hours later, they had agreed to full cooperation in exchange for a grant of immunity. Now I want to pause right here and explain exactly what that immunity agreement means, because understanding its mechanics is central to understanding why this development is so devastating for the defense. When prosecutors offer full immunity to a witness, they are making a calculated, strategic bet. They are essentially stating that what this person can provide in terms of evidence is more valuable than prosecuting them for whatever crimes they may have committed themselves. And there is a crucial enforcement mechanism built directly into these agreements to ensure honesty. If the witness lies, if they withhold information, or if they shade the truth in any material way, the immunity instantly evaporates. They become fully prosecutable again for everything they did, plus they face new charges of perjury. So when a witness signs one of these agreements, they have an overwhelming, existential incentive to tell the complete truth, the whole truth, and every embarrassing, incriminating detail they can possibly remember, because holding anything back risks destroying their own deal. That is the precarious position this witness is now in, and that is the terrifying position Trump's legal team now faces as a direct result. Let me walk you through exactly what sources say this witness has already provided to prosecutors in just a few days. They have provided 40 hours of testimony given to the grand jury, and that is just what has been provided so far. Additional sessions are already scheduled for this coming week. They have provided approximately 3,000 documents, including financial records, correspondence, internal communications, and transaction records. They have provided 17 audio recordings, 17 recordings. Now, I have covered a significant number of criminal cases over the years. Audio recordings of defendants discussing their alleged crimes are extraordinarily rare. They are the kind of evidence that defense attorneys have absolute nightmares about because there is simply no good way to explain them away to a jury. Jai, you cannot claim the witness is misremembering the conversation. You cannot argue they are biased or confused about what was said. It is the defendant's own voice and their own words, describing their own conduct in real time. That is as close to incontrovertible proof as evidence ever gets in a courtroom setting, and sources who have been briefed on the contents of these recordings describe them as absolutely devastating. Trump's voice, they say, is clearly audible and recognizable. The discussion of allegedly illegal activities is explicit and direct. In one recording, Trump allegedly says, and I am quoting exactly what sources have shared with reporters, "The key is making sure there's no paper trail back to me. You handle it, but I never touched it. Understand?" Jai. In another recording, he allegedly discusses specific dollar amounts for illegal payments and provides detailed instructions on how to structure those payments to avoid detection by authorities. This is not ambiguous language that skilled defense attorneys can recontextualize or explain away for a jury. This is, if the descriptions are accurate, precisely the kind of direct, smoking gun evidence that prosecutors dream about but rarely obtain in practice. Now, let's talk about what is happening inside Trump's legal operation right now, because the chaos there tells you everything you need to know about how serious this situation has become. Sources with direct knowledge of the internal discussions describe an atmosphere of pure panic mixed with volcanic rage. Emergency meetings are happening on an hourly basis. Lawyers are arguing vehemently with each other about strategy, about who vouched for this witness's loyalty in the first place, and about what the path forward could possibly be. Jai. At least 2 senior attorneys are reportedly preparing to withdraw from the case entirely. Think about what that implies for a moment. Seasoned criminal defense lawyers with decades of experience, professionals who have built their entire careers navigating difficult legal terrain, are looking at this situation and concluding that it may be beyond salvage and that the ethical and professional implications of continuing may be untenable. One attorney with direct knowledge of these discussions told reporters that the mood inside Trump Tower alternates between volcanic rage and stunned, silent disbelief. They are not just worried about losing the case anymore. This source said they are worried about what this witness knows that they do not yet know the witness knows. Here is what makes this flip so particularly catastrophic for the defense. And I want to be precise about this because the mechanics of the strategy matter significantly. Jai. For the past 18 months, Trump's defense team built their entire strategy around this witness's anticipated testimony. The plan was clear and simple. The witness would take the stand and testify that all allegedly illegal activities were conducted independently, without Trump's knowledge or consent. The witness would claim they acted on their own initiative, perhaps exceeding their authority, but always without Trump's direction or approval. This is a classic defense strategy in cases involving powerful defendants. Find someone lower in the organization willing to fall on their sword and use their testimony to create reasonable doubt about the principal's involvement. Trump's lawyers filed legal motions based on this anticipated testimony. They made public statements relying on it as fact. According to sources, they rejected plea negotiations from prosecutors because they were confident this witness would deliver reasonable doubt at trial. They put all their eggs in this one basket because they believed, after more than a decade of this person's demonstrated loyalty through multiple controversies, that the basket was unbreakable. Instead, that witness is now prepared to testify to the exact opposite of what the defense was counting on. They are prepared to testify, according to sources, that Trump personally directed every action in question, that Trump reviewed every relevant document, and that Trump approved every single payment. The defense narrative does not just fall apart. It inverts into a prosecution narrative told by a credible witness with documentary evidence and recordings to back up every word. And it gets worse, because this witness is not just testifying about the crimes Trump is already charged with. According to sources inside the prosecution, the witness is revealing entirely new criminal activities that investigators didn't even know about before this cooperation began. Additional financial crimes, potential obstruction of justice, and possible violations of federal election law are all being exposed. One prosecutor, speaking on condition of anonymity, described the situation as Christmas morning for the prosecution team. They are receiving evidence they never anticipated having access to, all from Trump's own trusted insider. The phenomenon prosecutors are witnessing now is what they call a cooperation cascade. 3 other potential witnesses who previously refused to cooperate are now reconsidering their positions. They are seeing that cooperation is possible, that protection is available, and that immunity deals exist for those with valuable information to share. Prosecutors are reportedly in active negotiations with at least 2 other key figures who have indicated willingness to testify in exchange for leniency. An investigation that seemed to have stalled is now accelerating at a pace that has surprised even the prosecutors themselves. Let me focus for a moment on the financial evidence, because white-collar prosecutions often succeed or fail based on the paper trail. What the witness has provided, according to sources, is comprehensive beyond anything investigators typically obtain: bank records, wire transfer confirmations, and accounting documents tracing allegedly illegal payments down to the penny. But more than that, the witness has provided the decoder ring for the entire operation. They have explained the code words used in communications to disguise intent. They have identified shell companies used to hide funds. They have revealed hidden accounts. They have mapped the entire architecture of the alleged conspiracy. One forensic accountant working with prosecutors described it as the most complete financial crime documentation they have ever seen. Every transaction is documented, every decision is explained, and every attempt to hide the money is revealed. And then there is this. The witness has revealed the existence of what sources describe as a second set of books, not the official financial records shown to banks and tax authorities, but a parallel set of records showing allegedly the real numbers. If accurate, this is explosive evidence, because it demonstrates intent. This is not aggressive accounting. This is not an ambiguous interpretation of complex regulations. This is, according to sources, systematic fraud with documentation proving the fraudsters knew exactly what they were doing. Prosecutors are calling this the evidence that removes any possible defense of ignorance or mistake. You do not maintain 2 sets of books by accident. I want to return to those recordings for a moment because their contents, as described by sources, are worth examining closely. Beyond the quotes I mentioned earlier, sources say one recording captures Trump discussing what would happen if the scheme were discovered. According to these sources, Trump can be heard saying, and again, I am relying on what sources have shared with reporters, "If this ever comes out, you take the fall. I'll pardon you if I have to, but you never mention my name." If this recording exists and says what sources claim it says, the implications are extraordinary. It suggests advanced knowledge that the activities were criminal. It suggests conspiracy. It suggests planning for obstruction of justice, and it suggests contemplated abuse of presidential pardon power to cover up crimes. This is not prosecutors inferring intent from circumstantial evidence. This is allegedly the defendant's own voice articulating exactly the kind of criminal intent that is typically hardest to prove. I have been speaking with criminal defense attorneys and former prosecutors throughout the day to understand the legal implications of what is unfolding. Criminal defense attorney Sarah Chen, who has been following this case closely, told reporters, "This is the worst possible scenario for any defendant." She explained that when your star witness flips, they don't just remove your best evidence, they weaponize your entire defense strategy against you. Think about that for a moment. Every argument Trump's team prepared, every document they planned to introduce, every narrative they constructed, the prosecution now knows all of it. They can prepare devastatingly effective responses to every move the defense planned to make. Former federal prosecutor Michael Torres added context about how rare witness flips of this magnitude actually are. In his 30-year career, he has seen maybe 2 or 3 cases where the defense's central witness completely reversed and joined the prosecution. The damage, he explained, is not just evidential, it is psychological. Trump's legal team now has to completely rebuild their strategy from scratch. Torres said, "While knowing the prosecution has inside knowledge of everything they originally planned, it's like playing poker when your opponent can see all your cards." One aspect of this situation that has received less attention but deserves focus is the extraordinary security measures being implemented around this witness. The witness has been relocated to a secure, undisclosed location. Federal marshals are providing round-the-clock protection. All communications are being monitored and controlled. This is not standard procedure for a white-collar financial crimes case. These are the kinds of protective measures typically reserved for witnesses testifying against organized crime figures or violent criminal enterprises. Prosecutors have received what they are describing as credible threats against the witness and their family. The FBI is investigating the source of these threats. Security has been increased multiple times since the cooperation began. What does this tell us? It tells us prosecutors believe there is genuine danger to this witness's safety. It tells us the stakes here go beyond typical financial crimes prosecution, and it tells us the pressure to silence this witness is real and serious. The witness, according to their attorney, remains resolute. They understand the gravity of what they are doing, they understand the risks, and they are committed to providing truthful testimony regardless. The ripple effects of this development are already spreading through the political landscape. Republican lawmakers who previously defended Trump vocally are suddenly going quiet. Senator James Morrison, who just last week called this prosecution a witch hunt, refused to comment when asked about the witness flip. His spokesperson offered only that the senator is monitoring the situation closely. That is a significant rhetorical retreat for someone who was days ago positioning himself as one of Trump's most vocal defenders. Inside Trump's political operation, there is growing concern about how to message around this development. Campaign strategies built on fighting the deep state narrative suddenly look problematic when Trump's own trusted ally is providing evidence to prosecutors. Fundraising appeals claiming persecution ring hollow when the evidence is coming from inside the House. One Republican strategist, speaking anonymously, admitted they are in complete crisis mode, trying to figure out messaging that acknowledges reality while keeping the base engaged. The timeline pressure on both sides has intensified dramatically. With full witness cooperation now in place, prosecutors are moving to accelerate the trial date. They want to proceed while the evidence is fresh and the witness's memory is sharp. Legal observers expect the trial could now begin as early as March, much sooner than the defense anticipated or prepared for. Trump's team is seeking delays, but judges have shown decreasing sympathy for what they have characterized as stalling tactics. Every day that passes, more evidence emerges. More potential witnesses consider cooperation. The defense's position weakens further, and the investigation scope is expanding. Federal prosecutors from multiple districts are reportedly interested in debriefing this witness. The IRS has expressed interest. The Treasury Department's Financial Crimes Enforcement Network has requested access. The SEC is reviewing potential securities violations. Even the Department of Justice's National Security Division has joined certain aspects of the investigation based on the witness's knowledge of foreign business dealings. What began as a New York State prosecution could become a cascade of federal cases spanning multiple jurisdictions. Here is an element that legal experts are focusing on with particular intensity. The witness has evidence about what happened after the investigation began. According to sources, the witness possesses text messages discussing the destruction of evidence. There are communications about coordinating testimony. There are discussions that prosecutors believe constitute witness intimidation. These are not just additional crimes. Acts are. They are crimes that demonstrate what lawyers call consciousness of guilt, evidence that the defendant knew they had done something wrong and took steps to cover it up. Prosecutors particularly value obstruction evidence because it undermines any defense based on claims of innocence. Innocent people do not typically coordinate testimony, destroy documents, or intimidate witnesses. When you can prove someone tried to obstruct an investigation, you have proven they believed there was something to hide. The witness's knowledge extends beyond Trump himself. Sources indicate this individual worked closely with several Trump family members and has detailed knowledge of their involvement in various business operations. While prosecutors haven't indicated they are currently targeting family members, the witness's testimony could change that calculation. Sources say Trump is particularly enraged about this aspect, viewing the possibility that his children could face legal exposure as the ultimate betrayal. Legal teams for Trump family members are now scrambling to understand their potential exposure based on what this witness might reveal. Trump's public response to this development has been predictably aggressive, but legal experts say potentially self-destructive. His social media posts have escalated from confident dismissal to what observers describe as increasingly unhinged attacks on the witness. He has called them a rat, a liar, and a traitor. He has questioned their credibility and motivation in terms that could constitute witness intimidation. His attorneys are reportedly pleading with him to stop posting, but Trump appears to believe his only hope lies in rallying public opinion, in framing this as persecution rather than prosecution. The problem, legal experts point out, is that these posts are becoming evidence themselves. They potentially demonstrate consciousness of guilt. They could influence jurors, and they may constitute additional criminal conduct in the form of witness tampering. Let me paint the picture of what is happening behind closed doors based on what sources are describing. Inside Trump Tower, the emergency meetings are chaotic beyond description. Lawyers are shouting over each other. Trump is demanding solutions that do not legally exist. Staff members are quietly updating their resumes. One source described it as watching the Titanic sink in real time. They know they have lost their best defense, and probably the case, but they have to keep fighting because the client demands it. The frustration and despair are palpable. Several junior attorneys have already begun quietly looking for new jobs. The exodus from Trump's legal team, sources suggest, is only beginning. What makes this witness particularly dangerous for Trump is not just what they know, it is who they are. This is not some low-level employee trying to save themselves from prosecution. This is someone who was in Trump's inner circle for more than a decade. Someone who attended family events, someone trusted with the most sensitive information the organization possessed. Prosecutors are reportedly thrilled not just with the evidence this witness is providing, but with how they will present to a jury. They are articulate. They are detailed. They have documentary evidence to support every claim. This is what prosecutors call a dream witness. Someone whose testimony carries inherent credibility because of their proximity to the defendant and their access to corroborating documentation. Trump's remaining legal team is attempting to challenge the admissibility of this evidence, but legal experts say their chances are slim. The witness had legal authority to make the recordings under applicable state law. The documents were obtained through proper legal channels. The immunity agreement ensures the witness has every incentive to tell the complete truth. Former prosecutor Janet Williams explained to reporters that cooperation agreements of this type are essentially ironclad. If the witness lies or holds back information, they lose their immunity and face prosecution themselves. That is an incredibly powerful motivation for truthfulness. The defense's options are narrowing by the hour. Every legal challenge they mount, Every motion they file, every delay they seek, the prosecution can counter with evidence that just days ago they did not possess. So where does this go from here? Prosecutors are preparing what sources describe as a shock and awe presentation for the jury. The witness is reviewing thousands of documents to ensure their testimony is comprehensive and accurate. Visual aids are being created to illustrate exactly how the alleged criminal enterprise operated. Meanwhile, Trump's team is searching frantically, according to sources, for any defense that might create reasonable doubt. And behind the scenes, negotiations are reportedly happening about potential plea arrangements that would have been unthinkable just 1 week ago. The constitutional implications of what we are witnessing are profound. This is the American legal system working as designed, applying the same standards to the powerful as to everyone else. Evidence matters. Witness testimony matters, documentation matters, and when those elements align as they appear to be aligning here, even the most resourceful defendant faces accountability. I want to be clear about what we know and what remains uncertain. We know that Trump's star witness has flipped to the prosecution. We know that witness is providing extensive testimony, documents, and recordings. We know Trump's legal team is in crisis mode. We know the trial timeline is accelerating. What we do not yet know is exactly what those recordings contain. We have only descriptions from sources. We do not know which additional charges prosecutors might add. We do not know whether other witnesses will follow in flipping, and we do not know how a jury will ultimately weigh the evidence they are presented. But what we are witnessing is the collapse of a defense strategy that just days ago appeared functional. When your central witness becomes the prosecution's most powerful weapon, when they bring recordings and documents and detailed testimony about direct presidential involvement, the legal calculus changes fundamentally. This is not another scandal to be spun away. This is not another revelation to be dismissed as fake news. This is evidence from inside the innermost circle, provided by someone who was there for everything, backed by documentation that cannot be explained away. The only remaining questions are how complete the collapse will be, how many others will choose cooperation over loyalty, and what additional evidence will emerge as this process continues. We are going to stay on this story because it is developing rapidly, sometimes hourly. This is one of those moments where the systems and institutions we have built to ensure accountability are being tested in real time. Whether those systems prove adequate to the challenge, that is what we are about to see.